Hi everyone. So you have immigration questions and I have answers for you today. A lot of you have been sending me questions, or these questions came from consultations I have had that people just have the same questions, and I want to answer those for you. I am U.S. Immigration Attorney Lilian, and I help my clients get green cards and citizenships for themselves and their families using the U.S. immigration law system. First thing first, let's talk about the biggest questions people have been asking me, which is about the fee change on April 1st, how that affects their process, right? If you're trying to figure out, whether you should rush your application and file it before April 1st or wait and file it later. Well, the biggest thing you need to know is, depending on what type of form you're filing, the fees are going to go up. So if you're filing a green card application based on marriage or based on being the parent or child of a U.S. citizen, well, the I-130, the I-130 and the I-485, those two are going up. Those two are going up, and you just need to know that. And then you can decide, right? You can decide if you want to wait or if you want to file ahead of time, right? Before April 1st. Here's how you can decide this. If you know that you want to include a travel permit, if you know you want to include a work permit with your application, you may want to file before April 1st because those forms are now going to have a fee. So if you file before April 1st, the fee for the work permit and the travel permit is $0, as long as you file it with the I-485, the green card application. The fee is $0. If you file it April 1st and after, now you have a fee for each of those forms. So the I-765 and the I-131 are now going to have a fee moving forward. But if you're filing it with your green card application, the I-765, the work permit, is now going to be half price. So before, the fee was included with the green card application, now you get half off. But with the travel permit, there's no half off. You're going to have to pay the full thing. So if you want to include all of the forms, you're basically going from paying $1,760 for all 4 forms to paying $3,005. So that is a huge increase, especially if you are filing for multiple family members now, right? That's a lot of money to put out. So you want to make sure that if you are already in the process, to start that going, okay? So before April 1st, the I-765 and the I-131 are free. After April 1st, there's now a fee for them, okay? If you are filing based on VAWA, though, right? If you're filing a green card application based on VAWA, based on U visa, based on T visa, guess what? The green card application fee is $0 starting April 1st. If you file before April 1st, right? If you file this week, you're going to have to pay the green card application fee of $1,225. But if you wait till April 1st and file your VAWA application with your green card application, with your work permit, with your travel permit, everything is free. You don't have to pay for anything. So before, what we used to do is file a fee waiver for our VAWA clients. But now they don't have to worry about any filing fees as part of their VAWA application starting on April 1st. So that's a huge, huge deal, because typically people going through the VAWA process have suffered abuse. They are not in the best financial situation to be paying for anything. They may have been living in a shelter because they're running away from their abuser. In those situations, now USCIS is saying you don't have to pay any fees. We'll take care of the fees for the green card application, the work permit, the travel permit. And if you need a waiver, they will also they will also waive the fee for the waiver. So any application you file that's in connection with your VAWA application, your U visa application, and your T visa application is now waived. And if you have derivatives, meaning you have family members, children under you that will get status because you're getting status through VAWA, U, or T visa, they also get the benefit of having the fees waived. So that is the big news out of that. So if you're in that situation and you are worried about filing for VAWA because you don't know where you're going to get the money to pay for the filing fees, well, you don't have to. You just have to wait till April 1st to file. We're waiting approval of the I-130. Should I apply for something else now to reduce the cost? Well, this is going to depend on whether the person is in the US or not. If the person is in the US, then there may be ways for you to reduce costs before April 1st. If the person is not in the US and you already have the I-130 pending, there's really nothing you can do to reduce costs because guess what? USCIS and the embassy are completely separate departments of the government. So USCIS is under Department of Homeland Security and the embassies are under Department of State. So their fees are different. Okay, they do not communicate as far as fees. Each department has their own fees. So the fact that the USCIS fees are going up April 1st does not also mean that the embassy fees are going up April 1st. Those are two separate things. So there's nothing you can do in that situation. However, if the person is in the US and they came in with authorization, right? They came in with a visa, they came in with parole, and their parole qualifies them for adjustment of status, they should be applying for their green card, the work permit, the travel permit now so that they can save that cost after April 1st. Okay. If they came in without authorization, there's really nothing you can do because you have to wait for the I-130 to be approved before you can do anything else like filing for a waiver or anything like that. All right. What are some requirements needed if you desire to travel outside the US for a month when you have extensions for the 8 months? So this is typically when you apply to either renew your green card or to remove conditions on your green card. What you need in order to travel in this situation is once you file for that renewal or to remove conditions, USCIS is going to send you an original receipt notice that's typically green, and you need to travel with that original receipt notice and your expired card. All right. If your card is lost, right, it's not just that it expired, but you don't know where it is, you need to contact USCIS and get an ADIT stamp because the only way you can get on a flight from outside of the US to the US when your green card has expired is if you have the expired green card and the original receipt notice. So the green receipt notice with the card gets you back into the US. If you lose the card, then you want to make sure that you are getting that ADIT stamp before you leave the US. If you're outside of the US already, you've traveled with your receipt notice and your expired card, and you unfortunately lose the card outside of the US, you need to immediately contact the embassy for something called a boarding foil. That's the only way you'll be able to board a plane back to the US. Okay? A boarding foil is basically something they put in your passport that allows you to get on a flight and be able to prove that you are still a permanent resident. All right. So those are the ways and procedure. As long as you have the expired card with the receipt notice that's green, you're fine to travel. If you've lost Either of those two things, you need to contact USCIS and get an ADIT stamp. If you're outside of the US and you lost either of those things, you need to contact the embassy and get a boarding foil. Should I put the receipt number when changing address? Is it okay if if I don't put the receipt number? So if you're doing a change of address online on the USCIS website, if you're doing a change of address, you have to put the receipt number. It's not going to let you do that unless you don't have a case pending, right? If you are a permanent resident, and remember, permanent residents have to update their address with USCIS within 10 days of moving. So if that's the reason that you're updating your address, you don't need a receipt number. You just have to check the box that says that you don't have a case pending. However, if you have a case pending and you're doing your change of address online, you need to put the receipt number just so that they update every single form that you have pending. And it lets you put multiple receipt numbers in there. If you're doing the paper AR11 does not have a space for receipt number, so you put your A number. So, but if you're doing it online, you have to put that receipt number. It's just the best to make sure that every single form that you have pending is actually being updated. What are the requirements for B2 visa holder need to meet to be able to adjust its status to study or work? All right. So those are two different things. So study has its own requirement, work has its own requirements. So I'll take those one at a time. For study, you need to show that you have received admission to a school and the school has to give you an I-20. Okay, that's the first step. Before you even get to a change of status, to study to the student visa, the F1 visa, you want to apply to the school, get admission, get the I-20. Typically, most schools will want you to show that you have the financial ability to pay for the school before they will issue you an I-20. Okay, so that's the first step. Once you meet all their requirements and they issue you the admission and the I-20, you can now apply for a change of status. Your B2 status needs to be valid. Okay, if you want the smoothest process from visit to student, your visit needs to still be valid. So if you came in and they gave you 6 months, you need to apply for the change of status before the 6 months is up. USCIS is now giving an exception for people that were not able to file within their stay because of extraordinary circumstances beyond their control. All right, they didn't give the definition of what extraordinary circumstances are, but I can tell you most of the time it's typically medical conditions, things that are typically beyond your control, not just that you forgot. Okay. So that's number one. Get your I-20, apply to USCIS. Applying to USCIS, you're filing Form I-539 with your I-20 with proof that you are still within your status and proof that you can financially pay for the school. So it's either you are financially paying for the school or you have a sponsor that's willing to pay for the school for you. If you have a sponsor and that sponsor is not an immediate family member, so it's not your parents or your siblings, there needs to be, this is what I typically recommend, a letter included to show why someone else that's not your parents, that's not your siblings, are willing to pay for the school, because typically we are talking thousands of dollars, right? Why the person is willing to pay thousands of dollars for you to go to school. All right. And you need to show that the person has the funds ready to go, right? Not that, they make enough income. No, that's not what the requirement is. They have the funds to pay for your first year of school in their account, in their investments, whatever it is. It needs to be something that they can actually withdraw. You can't just show, oh, well, they have properties. Great that they have properties. Are they going to sell the properties within a month to pay for your school? No. Okay. So they need to actually have the money in their account. And if you're doing the bank statements to show, you should also give months of bank statements, not just 1 month of bank statements. Like, don't just put money into an account just to meet the requirements, because USCIS is hip to that. They know that people will do that, so they pay attention. So you file your application, and then USCIS can get back to you and let you know if it's been approved or not. You can also, if you're close to your B2 ending, you can also apply. Also include a premium processing. So the premium processing, you can typically get a response within 2 weeks. So you know exactly where you are, and you don't have to overstay. That's another beauty of it. You don't overstay because you did the premium process and you found out in 2 weeks that yes or no. And if it's no, you were able to leave the US before you got any unlawful presence. Okay. For the work, you need an employer to hire you. Okay. For the school has to give you admission. For the work has to hire you and be willing to file an application for you, either a change of status to a temporary work visa, or an adjustment of status to a more permanent green card. All right, so that's the first step. You need to get the work. The only people that don't need an employer are people with extraordinary ability, meaning you are the top of your field. All right. If you can show that you are the top of the top, you most of the time are able to apply on your own without an employer. But for the majority of people, you need an employer. So that's the first step. Have an employer that's willing to file for you. The employer will start the process for you. So it's not, if you're doing an employment base, a work visa, unless you qualify to file on your own, the employer is the one taking the lead, is the one engaging with the lawyer to get everything filed for you. Okay. H1B season just ended. So typically that's the process people go through, the H1B. If they get selected for the lottery, then they start the visa process. But that's the process for work. We do mostly family-based and student, not really work in my office. So I'm able to tell you more about the study than the work. But that is the general things to know about that. My wife is a green card holder. She just filed for citizenship and had to put me on there as an overstay. Am I safe? Well, if she didn't put you on there, she cannot then file for you once she gets her green card, once she gets her citizenship. Okay. Um, the fact that you're on the application, there's always a risk, but the risk is higher if you have any negative interaction with the police, or if you accidentally cross the border, right? But if you are generally not engaging in any way with the police or border states, typically USCIS is not going to take actions based on your wife's application. But they do know that once your wife becomes a citizen, you would now, as an overstay, qualify for your wife to file for you. So most of the time in those situations, they may not take any action. Again, a lot of it depends on the individual and what their situation is. But generally, your wife filing an application for her citizenship would not typically affect you. But if she does not include you in that citizenship application, it will definitely affect her ability to file for you. Okay. So if that's the goal, is for your wife to file for you once she becomes a citizen, she has to include you in the application, or you are going to end up not getting your green card through her. Okay. If the child is over 21, can the step parent still petition for the child? Um, the marriage was before the child had turned 18. Great question. Great question. Yes. So once you meet the requirement as a step parent or stepchild for US immigration purposes, which is the step parent and the biological parents getting married before the child turns 18. That's it. That's what creates the step parent stepchild relationship for US immigration purposes. So once you meet that requirement, you have that for life. Okay. It doesn't just go away once the child turns 21. You just have to show that you met that requirement before the child turned 18. So once you're able to show that, you are still their stepchild there, and you are still their step parent. Okay. So even if the child is over 21, you can still file for them just like they were your biological children. The only time that this kind of changes is if, for example, you get divorced from the biological parent. You just have to show that you maintain that relationship with the stepchild, okay, in order to be able to file for them. But their age at the time of filing does not matter. It's their age at the time of marriage, okay? At the time you married their parents, how old were they? If they were less than 18 years old, even if it's a day less than 18, they qualify as your stepchild. You qualify as your step parent for immigration purposes. And remember, this goes both ways. The step parent can file for the stepchild, and the stepchild can file for the step parent once they turn 21. Can I file my stepchild's petition in the same document with my spouse adjustment of status? No. This is always a great question because people want to think that if you are filing for your spouse and they have children, you can just include the children in their application, and that also includes the, everything. Everyone just gets a green card at the end. Unfortunately, if you are a US citizen, each person needs their own application. So your spouse needs their own application, your stepchildren need their own application. You cannot combine those. Okay, so each person gets their own I-130, each person gets their own I-485, their own work permit, their own travel permit, anything else you want to include, their own affidavit of support. Okay, every single person gets their own individual form. Now, if you're a green card holder and your spouse is outside of the US and you're filing for your spouse, guess what? You don't have to file a separate petition for your stepchildren. Okay? The only time you have to file a separate petition for the stepchildren that are under 21 is if you are a US citizen. But if you are a permanent resident, they can be included in your spouse's I-130. But then when you get to the embassy stage, each person will need their own visa application. And if you want to schedule a strategy session to talk about getting help with your green card process, your citizenship process, you can go to my website, lilylegal.com, or call my office at 508-443-1788 just to schedule that strategy session and get you on the right track to your green card.